Welcome to the Turnaround Podcast with your host, Stephen Phillips. In each episode, Stephen speaks to experienced practitioners who discuss their careers, key moments, challenges, and lessons learned in financial turnarounds and business restructuring. Join us as we unravel the secrets to turning struggling businesses into success stories. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, frylibertas.com. Now, here's the host of the Turnaround Podcast, Stephen Phillips.
Welcome to the Turnaround Podcast with me, Stephen Phillips. On the 15th September 2008, Lehman Brothers filed for bankruptcy in the United States, swiftly followed by subsidiaries all over the world, including Libby in the UK. Pressure on Lehman and many other banks and institutions had piled up in the months before. The crisis had its origins in a downturn in the US property market, where subprime borrowers began to default in 2006-07. A number of hedge funds connected to asset-backed securities, which had brought structured credit instruments linked to properties, such as CDOs, had failed as the market suddenly lost all confidence in the value of structured credit assets. The news suddenly was full of strange words and acronyms like subprime, MBS, CDO square, CDO cubed, structured investment vehicles. The initial hedge fund failures were the canary in the coal mine. Bear Stearns, an investment bank, needed to be saved. But the failure of Lehman was the inflection point. Credit markets had a heart attack. The credit business practically stopped. Many major banks failed and needed to be bailed out. The world's financial system had, for a time, failed. Needing liquidity or being forced to sell as collateral calls were made, fast sales of assets such as CDOs took place. The most liquid assets being sold first, and the more complex seemingly losing all value, as the loss of confidence often led to people to attribute little value to them. Stock markets suffered massive falls. It was, without doubt, the most extraordinary time. In the UK, Lehman's counterparties were unclear as to whether over 840,000 trades would go on to settle, while clients had more than 35 billion in cash and assets tied up in the insolvent estate. Complex questions arose as to who did these assets belong to. Once Lehman failed, the impetus to intervene to stop the contagion became overwhelming. As Ben Bernanke famously said, there are no atheists in foxholes and no ideologues in financial crises. It was an attitude adopted by the authorities all over the world, where they put all moral hazard arguments aside and did what they needed to do. I was a partner at one of the global law firms at the time and suddenly found myself looking at custody arrangements between banks and their clients, and trying to work out how hedge funds and banks caught up in the contagion could be saved. As the downturn spread its sweeps into the real economy and a severe recession hit, it was, to say the least, intense. To try to make sense of the legacy of Lehman and the regulatory reaction which resulted, I have asked somebody to join me today who had a ringside seat during this time. Barney Reynolds, partner at newly merged firm A O Sherman, an expert in financial services regulation. Welcome to the Turnaround Podcast.
Thanks very much, Stephen. Delighted to be here with you.
Fantastic. Well, thanks for joining. We've got sort of 45 minutes and one of the most ambitious discussions I've tried to have on this show, given the depth of the issues. But I want to discuss two things: the massive regulatory reaction which resulted post Lehman, and if we have time, the UK has gone through its own major restructuring, which we're calling Brexit. So if we've got time, let's talk about that first. But before we do, can you just give the audience a little bit of a flavour of your career and what you do now?
Sure. Well, I'm a financial services lawyer. I specialize in advisory work and some transactional work for financial institutions, occasional disputes, helping them optimize their businesses under law and regulation. I started in the 1990s, the early 1990s. I've been around throughout the evolution of the regulatory scheme to its modern complex state, and I was around through the financial crisis, 2007, 2008, and through Brexit. And I've also got wider legal interests in legal systems, how they're set up, how they can be optimized, the difference between the various legal methods in use around the world, and the reasoning techniques. And I led a team setting up Abu Dhabi Global Market, which is the first common law financial center set up in the private context in the world in 2015, and is now over 2.5% of Abu Dhabi's GDP.
Fantastic. And maybe you can give us a bit of a flavor of what you were doing around the time of Lehman and how that affected your career and the maelstrom that was happening there. I'm sure people were giving you calls all the time.
Yeah, I was advising a number of institutions on the situation, and then that carried on. I was helping them interact with legislators and regulators on the aftermath, and also it led to a whole lot of deals, M&A deals. I mean, in my case, I worked on an awful lot of them across Europe, bank restructurings, capital raisings, and so on. And at that stage, I wasn't a writer or a public sort of analyst, thinker. So I had my own private thoughts, which I communicated with regulators and so on about the future direction on behalf of clients. I actually almost regret that I didn't at that stage sort of write some of this up, because I think some of the reaction in the regulatory context was overdone. And in fact, we're living through sort of rowback on that now.
Oh, let's get into that. So I think it's just a bit too much for us to try and talk about the sort of the individual decisions that were made almost on an ad hoc basis as Lehman unfolded. In a way, I think that goes back to the comment that I made about Ben Bernanke, which was, there was a bunch of ad hoc things that just had to be done. But what I'm really talking about today, or what I'd like you to talk about, what were the individual longer term bits of legislation that came in that were the big regulatory reaction as a result of Lehman that probably took some years to sort of unfold. But what were the big things that spring to your mind as the reaction?
Well, I think stepping back, the thing that was missing from law and regulation globally before Lehman was sort of a scheme that addressed systemic risk. So all the things like the European M&A deals I mentioned, the Bank of America Merrill Lynch deal, which I was involved in for Merrill Lynch, all of those sorts of cleanup things where balance sheets are put together, positions closed out, and so on. Very complicated stuff that you were involved in. All of it was dealing with the symptoms. The cause was the assumption on the basis of the then thinking prior to 2007 that the financial market operated efficiently on its own, and regulation didn't need to be particularly intrusive or managerial, because very bright people in each of the individual institutions would evaluate for their own institution how strong their counterparts were, and through that process, bad banks would be effectively wiped out of the market and good banks would thrive. The error in that thesis was that not everything was visible to each bank, and so it was not possible for individual firms, however well run, the efficient market hypothesis was the notion, to work out who shouldn't be in business doing business with them. and so they could shun those, and they could ramp up their dealings with the better businesses. So with that cause in mind, what the legislators and regulators did post 2008, when they started on a whole scheme of creating a new architecture for regulation, first conceived actually in the UK by Adair Turner, the Turner Review, the Turner Report, and then adopted, I think the US came next with Dodd-Frank, European Union with MiFID, and then MiFID II, EMIR, patches on that. All the various regulations around financial services, including ancillary industries which hadn't been involved in the crisis, but where the thinking of those involved at the time was that it could happen, so that they were dealt with as well. So Solvency II for insurers, AIFMD for asset managers of big PE funds and hedge funds themselves. All of this was designed to pump information out into the market so that the efficient market itself could work more efficiently and weed out bad actors better. So the thesis was, that the information had been inadequate. And then also more managerially to control financial businesses, particularly banks, which are engaged in the maturity transformation business of borrowing short and lending long, as it were. Not short, borrowing on short-term basis and lending on long-term basis. Sitting in the middle, so obviously, if people will ask for their money back, you've got to realise longer-term assets or borrow against them to repay. That led to a whole panoply of changes, including much larger capital requirements designed to cushion against that risk, and the oversight of senior managers in the UK, but not totally dissimilar things elsewhere, and much more of a proactive look at how particularly banks, but also other financial firms were run. So basically, that's the architecture of what then got rolled out. Because each of these initiatives were produced in parallel to some degree by different people to some degree, although under some sort of coordinated thinking, Turner Review I mentioned, you ended up with a situation where safety belts were piled on safety belts, which has led to a separate problem we now have, which is the bureaucratization of banks and the undervaluation of banks and the in fact a restriction of banks, I think too much unnecessarily, because there was a reaction against the abilities of the market to be efficient.
Right. So I think you're in some ways alluding, you can see this in the share price of most of the major UK banks. They've kind of gone sideways for 10 years. And I'm presuming that is showing your hypothesis, which maybe too much risk has been taken out. Is that a fair question or assumption?
Yeah, I think so. So what has happened? So after 2008, when this big program of regulation legislation happened globally, with swathes of rules being produced on both sides of the Atlantic, in Europe using the code-based method of lawmaking, which is a sort of continental method that comes from 19th century France and Germany. In the US, the common law method. Now the UK, outside the EU, living in the common law method and moving back towards that. One has to understand that difference to understand anything. The volume of those rules meant that big consultancies and non-lawyers were pulled in to create compliance processes. I've already said, and I think there are the volume of rules was overdone, and I think some of that can be refocused now. Some of it is being refocused, but there's more work to be done on that, and that's by legislators and regulators. In addition, and in parallel, the financial firms themselves, because of this deluge, have created massive bureaucracies to some degree, which are go beyond what is absolutely essential for the compliance with these rules. That's created its own problems. And in particular, sort of slightly wooden interpretations of the rules, where rules and the meaning of rules are treated as points of fact rather than something that's nuanced and contextual. rather than looking at what you're trying to decide and evidencing that with the relevant evidence, there are a lot of committees involved, such that a lot of leaders of major financial firms, particularly banks, are in back-to-back meetings throughout the day, rather than engaged in commercial management to the degree that they were before the crisis, and they are in other industries. So I think that phenomenon, so somewhat of an overreaction on the scale of regulation, the reaction of the industry to the regulation, has created an environment where a lot of the very smart people in banks aren't able to exercise commercial judgment to the normal degree of any normal industry sector and other industry sector. So I think that's led to an undervaluation. I think it's led, the regulators themselves apply top-up capital charges because they're not entirely sure all the capital will fully achieve the results that they've got. So there's sort of discretionary top-ups. And then on top of that, you've got the shareholders looking at banks where stuff happens, like Credit Suisse, SVB. And so I think there's a discounting for that as well. So that, the bank management, I think, are held back by the rules, and then people looking outside in are wondering, whether this is all working sufficiently. And then in parallel to that, I think there's the data. That the rules were created around old data technologies with relational databases which are constructed in order to achieve, to gather data and analyze it in a very specific and way, where the data relationships between data are hardwired into the system. Yeah. Whereas nowadays, with big data techniques in other industry sectors, you can have a flat file without preconceived relations between the data. And what it's now possible to do using big data techniques, and I think the banks should move to this, is to get data, fully granular data on all the cash flows, so you can match things up and work out what the risk is of money coming in at Tuesday at 2 p.m. And if it doesn't come in at 2 p.m., how do you make this payment out at 3 p.m.? Are you going to be able to borrow at the time? What's it going to cost you, and so on? So in summary, I think my view is, obviously there's a wider picture that banks live in, which is driven by interest rates in particular. But I also think, though, that the bureaucratization of the banking industry through over-regulation to some degree, and the response to that, which I think has been over-bureaucratic, in parallel with banks having sort of insufficiently granular data, has meant that investors are discounting the value of the banks. And you mentioned the UK. It's actually global. So in Europe, banks are generally trading at under book value, at around book value. And in the US, there are some under book value, but there, a handful barely above book value, maybe 1.5 or whatever. But you'd expect, I would anticipate that in a normalized industry, they should be trading at 3 or 4 times book. That's not happening. So I think this is why. I think it's because they're not able to go out. They're not, because of this bureaucracy, because of the data point, because of the discount of the investors, because of the top-up capital requirements of the regulators who aren't completely sure that everything is fixing the problem. They're not able to manage the risk holistically as they could do and should be able to do for the benefits of the real economy.
I think one element of the discount which may make sense is I think in the past it was actually pretty difficult to resolve a bank, and it meant that a number of banks and their shareholders ended up perhaps being bailed out. There wasn't the sort of sharp resolution procedure available. Obviously, that then changed. That was part of the regulatory reaction that there are bank resolution tools, etc. So I suppose you could say that as a shareholder now, that if there's a real problem in the bank, you can't expect the authorities to just sort of pump money in or ensure that there's some kind of bailout. So I suppose that is natural. And I would say from the outside that has been one of the more successful and sensible reactions to the legacy of Lehman. I don't know if you have any comments on that.
Yes, the bail-in or the resolution frameworks, which existed in the US, to a degree, before under the FDIC system, then taken as a Paul Tucker idea, actually, taken the bail-in concept, wipe out the equity, convert debt to equity, and recapitalize the bank that way. It was rolled out across Europe, first in the UK, and then mimicked in the BRRD, the Bank Recovery and Resolution Directive, and then it's been tweaked since then. I mean, there have been several BRRD bailouts in Europe, in the sense that the BRRD was the backdrop for those recapitalizations. But actually, the use of BRRD has been very limited, and it was used, I think it's fair to say, in Banco Espírito Santo, which led to a lot of litigation about how it was used.
Yeah.
It moved some money from hedge funds and banks from the bad bank to the good bank, I think, to the bad bank, and then there was arguments whether they should move it back and so on. And there were arguments about whether they checked for private sector options sufficiently before and so on. But actually, most of the other recapitalizations in Europe, like the Greek ones, right? In fact, Colt Bank in the UK twice were private sector against the backdrop of this law. So nobody, the full use of the BR, and one of the reasons for that is that at this time, and it's getting better all the time, particularly in the UK. The capitalization of the banks and the capital stacks were insufficient for a full BRRD thing, so it had to be a private sector step, and it wasn't actually used the equivalent in Credit Suisse even, right?
Yeah.
It was a governmental edict that wiped out or hit the AT1s, but not the use of their equivalent to the BRRD. And part of the reason for that, I think, is that the capital stacks have been insufficiently reorganized in many cases for the retail element. So the regulators haven't been prepared, or the resolution authorities, to go through with a BRRD restructuring, because it would involve hitting the retail, and then you need, that's massive consequences of that. That's obviously being ameliorated as banks with capital stacks are being redone. But even so, I think BRRD is a sort of framework that has ameliorated things somewhat. Whether it has, and retail, of course, is then often protected, as it was in SVB, in extremis anyway, because there's a confidence issue in the banks. So whether it's fully fixed the idea that for very major systemically important situations, it's not necessary to have some sort of state involvement, I'm not entirely clear. So I think it's partially true what you're saying. I think it's made it, like Credit Suisse, it could have been done. I think the UK would have done it. The Bank of England said so. So I think that's a good example of what's been achieved, although it wasn't done. But I think there are limits, and SVB was an example in the US of where actually, despite all of these efforts, the tax, and despite Dodd-Frank saying that no taxpayer money could be used effectively, it was.
Yes. Yeah. Well, I'm certainly an advocate of private sector solutions before the heavy hand of the regulator steps in. It's just an observation I would make that it's in the background there in a way that it wasn't during the 2008 crisis. Switching a little bit. I don't know if you got any comment on trade settlement and the setting up of these what are they called, the CCPs that basically are between the banks and the funds, and you end up in these central counterparties instead of being opposite a bank. You've got a central counterparty in the middle that sort of is one end of the trade. Have you looked at that, and is that something you think was a good idea, and is that going to your efficient market hypothesis and more information flow, etc.?
Yes, they're really the plumbing of the financial system, or a large part of it. They existed before the financial crisis, right? For all sorts of different types of financial instruments. In the financial crisis, Warren Buffett famously said that credit default swaps were instruments of mass destruction. And I think it was number 2 or number 3 on the G20, Gordon Brown, Obama list of, essential action items post-financial crisis to address credit default swaps, which were then put into clearing with a central counterparty. And then there's an increase in clearing of financial instruments, derivatives particularly, in central counterparties, driven by the fact that you then had in Dodd-Frank in the US and EMIR in Europe, now UK, EMIR in the UK, an ability for the authorities to identify the sufficiently liquid instruments and whether you're sufficiently uniform, and you put them into a central counterparty. That massively de-risks the system. And in fact, I think it's one of the biggest contributions of that whole stream of thought post-2008 to the reduction of risk in the financial system, because the central counterparty basically collapses a bank's exposure, a clearing member's exposure. It takes on all these exposures from its customers and from itself, and faces one central counterparty, and therefore can net down, trillions of risk to a much smaller number, not zero. And that's an equal and opposite side, dispersed around all the other members, because every trade has an equal and opposite. So the central counterparty sits, as buyer to every seller and seller to every buyer. Is the famous description. And there are, lots of smart people sitting there running the central counterparty to keep a flat book so that it doesn't actually run any risk itself. It has an equal and opposite exposure to everything, and powers in its rule books, which is essentially its contractual framework, to normalize and flatten the risk if anything happens. And it's been extraordinarily successful. So I think it's a big step forward behind everything. BRRD, actually, you're right, it's another one. So if you add all of these things up, it's like safety belts on safety belts, but those two are actually parallel safety belts. They're not on top of each other. They're de-risking the system.
And let's talk about sort of the senior managers regime. What happened? Because a lot of people sort of felt somewhat aggrieved that the banks, no one went to jail really over what happened. Do you think that the regulatory regime is put more responsibility on individual senior managers?
Yes, so this is a UK regime, not replicated as a pan-EU level.
Yeah.
And not replicated actually in the US. What it does, and it has had ripples though all over the world, so it's just not in the law, but the technique has been followed to some degree. What it's done is required banks at the very highest level, board level down, to identify who's responsible for what, with a chain of command up and down. So if something happens, you can see exactly who's involved in, and who was responsible for making sure it shouldn't happen. And that wasn't the case before 2017, before the financial crisis. And you're right, it's one of the criticisms of the law at the time, which is lots of people then sort of pointed fingers at each other and nothing happened. So it fixes that. In the US, the sort of governance is more fixed through the board. So the US regulators come in and talk to the board and require, and evaluate how well the board's doing its job. UK does that as well, but you've got the senior management regime, which goes into the executive level as well as touching some of the people on the board. In Europe, it's more day-to-day interactions to the regulator at both levels. But essentially, it's designed to achieve that. The only thing I'd say about the senior managers regime, which I'm not certain is properly calibrated right now, and the UK is looking at again, is because there's a parallel regulatory sort of rule book, if you like, in a way, for the senior managers to that applicable to the firm they manage. There's sort of almost double jeopardy, which is obviously, as a legal matter, unacceptable. And it's not entirely double jeopardy because they're not liable themselves twice for the same thing. But essentially, as a senior manager, if there's a fine against the firm, it's very difficult to resist the idea that the people responsible for the relevant topic aren't automatically responsible for it at the same time. And I think that is unfortunate. So I think there needs to be more legal thinking around exactly who should be responsible and when, validly, for that system to be nuanced. And I don't think it has been sufficiently nuanced yet.
Right. Another observation I would make is that it feels to me that a lot more financial services are now being provided by funds rather than the banks. That there seems to be far more activity in the major kind of alternative asset managers, etc. Is that just a market trend, or has that been driven by regulation?
So I think it's largely, very significantly driven by regulation.
Mm.
So it's cost of capital for the banks was mushrooms in order to try and deal with systemic risk. Before, the regulators were just looking at what they call idiosyncratic risk, the risk for each financial institution, assuming that the efficient market would do the rest. Then they've added in capital for the whole system, and they've added in all these other rules that we talked about and many more besides. So what's happened is some of the smartest people in the banks, not all of them, there are very clever people there still, have left and set up funds, hedge funds, private equity funds, and so on. And those are very lightly regulated, particularly in the US, but in Europe, there's the Alternative Investment Fund Managers Directive, which provides some level of regulation, but nothing like bank regulation, no capital regulation, or anything that replicates the bank situation. So what you have is funds borrowing partly from the banks and partly originated by the banks from their customer base. But the fund is performing the function in a way for itself of the old credit committees of banks. So they're then making loans and buying up assets in the market and engaging in heavily leveraged transactions with money either originated by or provided by the banks, a lot of it. And also massive private investment for other funds and private investors. I think the regulators' view is slightly uneasy about the situation. So partly the thesis is, well, it's private sector, wholesale money. These guys can look after themselves and check that the funds are doing the right thing. Nevertheless, there is increasing concern about the systemic risk. If something happens systemically, the risk of contagion from something that happens to a number of funds at once, or one fund triggering a systemic risk, with the other funds and the banks and so on. But the point hasn't gone away, and it's being looked at. And so then the thinking is broadening. There's a competitiveness issue behind what they do, though, which is the funds are totally mobile. So the regulators don't all agree what they're doing and do it in lockstep. Funds will just say, fine, you don't want me, I'll go somewhere else. So it's a very difficult thing to deal with, except on the basis of consensus. But that consensus building and thinking is happening, and the US are looking very heavily at it. And I think there's more to happen in that space.
Okay. Now, before we turn to that other big restructuring, Brexit, I just want to give you an opportunity to say, is there anything that, if you happen to be in charge of things, that you would put in place that you think regulators are missing a trick?
I don't think the regulators are missing a trick.
Or the parliamentarians? Yeah.
Well, I think there needs to be more accountability for the regulatory system under the law. So, and this is an issue. So take the two common law jurisdictions at the centre of the global market, the US and the UK, both hosting the two big global financial centres.
Yeah.
Both got the law of judicial review. The law of judicial review was developed to provide checks and balances on effectively what we call over here ministerial accountability. And it's very deferential to ministers. So it had to be something that, either they do something illegal or something that no reasonable minister could have done. That's been applied to the regulators. And what it means, and there is in the UK process of a rehearing thing, but it essentially operates, in my view, more or less like a judicial review. It's very deferential to the thinking of the regulators. In practical terms, what that means is you've got a whole industry of people based on the thesis of a regulatory relationship. So we're feeding the dragon and keep these people happy. It's all to do with, you can't push back too hard on that topic because he might upset them and so on. So it's taken a sort of grown-up discussion out of the system to some degree, or weakened it. And I think it's only possible to have that if there's someone above the regulator that one can go and say, look, they're not applying their rule book properly. You've got line regulators coming and telling us to do this, but it's gone beyond their powers. And I proposed some amendments to the Financial Services and Markets Act last year, which I think would have fixed the point. I do think that needs to be looked at, and it's the same sort of issue in the US. Justice Gorsuch, Associate Justice Gorsuch in the Supreme Court of the US, United States, has been looking at the Chevron doctrine and the idea that the regulators shouldn't be able to determine the ambit of their own powers. Massively watered down through Supreme Court action, not judicial action in the US. That sort of helps. It's not really the point I'm talking about, which takes it one stage further, which is I think the regulators should be required to make rules that are clear and apply the rules consistently and predictably under the common law method. On the continent, you can't achieve the level of legal certainty that you can in a common law system, in a code-based civil law system. You can't, which in my view is one of the reasons it's sort of chalk and cheese, and it's almost why, to my mind, the different legal methods and reasoning processes are almost why Brexit, to my mind, touching on the next topic, was inevitable, because I just think people are talking past each other all the time in terms of how they reason. But in the continental system, it's going to have to be much more managerial, and there needs to be, more reasoned discussion with the regulators it has still to be based on legal reasoning, but getting the courts into the process is something much harder to do in a code-based system than in a common law system, and therefore, it just doesn't happen as much. There's much more deference. The whole system is designed to achieve a managerial outcome. And so the technique for addressing it is going to be slightly different. I don't think you can ever get to the same level of individuality and entrepreneurialism in that system as you can in a common law system, properly optimized.
Okay. Well, we did touch on Brexit, and you've been a very vocal advocate, actually, of Brexit. And it's been very interesting seeing your career develop, actually, because I think many lawyers in the city are, they sort of duck under their desks when any kind of political issue turns up. And I actually think it's impressive that you've taken on a bit of a sort of a role as a kind of reviewer of Brexit and a thought leader. Tell me, how do you think it's been implemented? Has it been beneficial? Well, let's just do those two first, and I'll go to the third question.
Well, I don't see myself as having advocated Brexit, although for the reasons I just mentioned, I think it was inevitable at some point. It hadn't been now; it'd been not that far away, because the fundamental differences and techniques which arise from the legal systems, the different systems of reasoning, which started from the 19th century codifications on the continent, that just creates an entirely different way of thinking and reasoning, which the UK is permanently puzzled by and uncomfortable with. And I don't think ever there was a majority in favour of a closer union. But actually, I wasn't advocating for it. What I was doing is saying, well, okay, if you're going to do it, this is how you do it. And I've spoken and written an awful lot about that. And it's a legal event, and it requires a legal disentanglement, first of all, from the treaties, which needs to be done properly. It hasn't been fully. And then secondly, it needs to pivot back to the UK's traditional method of reasoning, which involves common law thinking, which isn't just to do with case law, it's to do with the whole value system that it embodies and reflects. And that, so that's what I've been writing about and doing, and advocating that if we're going to do it, we do it properly, because otherwise you don't see, otherwise you're betwixt and between and everyone's frustrated. It hasn't been done. It hasn't been executed particularly well, unfortunately, because I think, as a legal project, our system and most of the establishment in the country are oblivious to these legal points, not really interested in them, don't really think they matter to the degree I believe they do. And so the negotiations were conducted by professional negotiators using largely political and diplomatic means. So initially with the May Robbins team, it was sort of private conversations for years, which achieved something that was then rejected by our Parliament 3 times. Then under the Johnson Frost team, Frost famously saying no to all sorts of things, but there was no real reasoned ask. And so I think it's very unfortunate that, and then, the Windsor framework, in a way, was an opportunity where that could have been fixed. It wasn't taken. I mean, I appreciate it's difficult doing all this stuff. I think so we've been left with EU law being received for industry and agriculture, physical goods, in Northern Ireland and actually de facto across the UK, because if we diverge, in inverted commas, in Great Britain, it'll create more of a border across the Irish Sea, which would be politically unacceptable, and push Northern Ireland further out of the UK. So that was an error. And state aid law applicable to the whole of the UK, which hasn't yet reared its head, but effectively means that an electric battery manufacturer in Sunderland has to worry about EU state aid oversight and whether a subsidy is given for that is properly valid or has to be repaid if the Commission objects. And then you've got inherited EU law, 170,000 plus pages of it, then called retained EU law, then now called assimilated law, basically untouched. And that has been produced on the code-based method. And that goes beyond industry and agriculture, it goes to financial services, data, all these other areas, which operates, and it creates and drives an economy quite different from the traditional UK common law model. So our model operates on entrepreneurialism, individualism, small and medium-sized enterprises constantly competing and developing new things. And we know it works. We've had it for hundreds of years. What the continental model from the 19th century drives is a managed economy, much more consensus between big industry and regulator and government, which our system is just not set up to achieve. So Parliament has massive statutes coming through that are an inch thick that people don't have time to properly examine, let alone cross-examine in terms of how they're constructed and so on. So we're just not set up to run that sort of system. So I think it's not been done properly. Now it can all be fixed. We've got the powers under retained EU law Act 2023, to deal with retained EU law. And the Northern Ireland Protocol, Windsor Framework thing, can be torn up under international law because it is not a sovereign agreement. And there are a whole load of reasons why that's the case. So this can all be fixed, but we do need that sort of legal thinking at the heart of our system so we actually can start dealing with this and then moving and pivoting back to our more, free market way of doing things, which would be much more like the US, but different because we do things in our own way.
Got it. I guess, my question is that if the opinion polling is to be believed, we are likely to have an incoming Labour government. What do you think their attitude will be? And it feels to me like they're always going to be under pressure to get closer to Europe, etc. Do you think there are going to be very significant changes, or actually will they suddenly find that getting closer to Europe means giving up so much that actually the negotiation doesn't work? Do you have a view on that?
Well, obviously I can't speak for them, but my belief is that, consistent with what I've just been saying, this is a legal thing. This is not political at all. Right? There are Labour thinkers that get this. Some of them no longer in the country, like Brian Gould and so on. But there are sort of sophisticated Labour thinkers that get the legal aspect. So it's not about, in my view, it's not about a close. I think it's all to do with the words. It's not about a close relationship with the EU, or the continent, which the UK, I suspect, by majority needs and wants. That it's a question of how it's done, and the whole dialogue at the moment is misdirected, to my mind, because a close relationship doesn't mean following EU rules. I mean, that is an absurdity which has tangled us up in knots in the Northern Ireland relationship and is also holding the country back in terms of retained EU law. Close relationship has to be done through a sovereign-to-sovereign arrangement that matches up, joins up our common law way of thinking with the code-based continental method. We're out of the EU now, we're out of the government, so we can't be under a code that's made under a foreign government and applied under a foreign government, which we never fully understood or engaged with anyway, and we can't manage. We haven't got the institutional setup to manage that code system. So I think it's the wrong question. So I think it will become apparent when people who are not operating with the legal thinking come back, having spoken to people in Brussels, to say, well, you can do this if you want, you can copy these rules and so on. I think they'll find that the propositions don't chime in the UK. And so I think that will then lead to a reevaluation of the necessity to get some of this nuance of legal method right. And it may have already happened. I don't know. I mean, I don't know where the thought process is, but I think there's an inevitability around this. And my pitch to get on with it is that the country's economy needs to grow. The reason it hasn't been growing as fast as it has historically is that in 2009 and so on, our rate of growth, flatlined in Greater London, and it massively depleted for the rest of the economy. And I think that's an awful lot to do with the application of EU code to financial services. A lot of the rules are talking about, but also how they were done. For instance, banking rules were applied to all banks, including small ones that don't present the same risks at all. And they were not nuanced even for bigger banks. So what you have is this sort of blunt instrument, which has reduced lending to the SMEs, which are the lifeblood of the UK economy. And that has held the country back. And it's only by releasing from all of that and getting the lending going and the economy going and getting the growth that Labour are going to have the wherewithal to tax and redistribute in the way they want. I mean, the political overlay of whether you believe in an autonomous environment, more individualistic autonomous environment of the Conservative Party, or the sort of redistributive environment of Labour. I mean, that's the choice that's been there for generations and will continue. But on either route, you need an economy that's growing, that's operating, in my view, on our common law system with the infrastructure to match and our institutions managing that properly. And so my pitch to them would be, if you do this right and get on with it, you will then get the wherewithal to do all the other things you want.
Great. Well, Barney, I think we've taken up a lot of your time. Really appreciate your thoughts. They've been very interesting. I think it's the kind of thing that we could have had 10 programs on instead of one. So thank you very much, Barney.
Thank you. Pleasure. Good to see you, Steve.
You've been tuning in to the Turnaround podcast with your host, Stephen Phillips. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, frilibertas.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.